Civil 101. Pay attention. Today we're going to talk about parties. No, not that kind of party. Parties to a civil action. Specifically, we're going to talk about types of parties. We have the proper party, the necessary party, the desirable party, and the nominal party. Proper parties are parties who are directly involved in the course of action. So for example, if there are two people who enter a contract and there is a breach of contract, if one party decides to take legal action, then both parties to the contract will be proper parties in the civil suit. In the case of Mobile and Lasepa, it was held that a proper party is one whose interests will be affected directly if a relief claimed in the action were granted. The non-joinder of a proper party may be fatal to a suit. As for necessary parties, a necessary party is a person who is not only interested in the subject matter of the suit, but if he is not there, then the proceedings cannot be dealt with fairly. Now, in an instance where that person is not in the suit, such a person ought to be joined in the suit. In the case of Union Beverages Limited and Pepsi Cola International Limited, the courts held that where a complaint is made against someone in an action, and the issues involved in the complaint cannot be effectually and completely determined in his absence, such a person is a necessary party. A good example of a necessary party is INEC when it comes to election petitions. This is so because INEC is not only interested in the subject matter, but if INEC is not included and there's a relief that affects it, what that would do is that it will rob the court of the power to make an order on that relief. This is a good time to state that while all proper parties are necessary parties, not all necessary parties are proper parties. A desirable party is someone who has an interest in the subject matter of the suit, or who may be affected by the court's decision, but his absence might not affect the judgment or just determination of the case. So a practical example of this is where in a civil suit, the landlord who owns property is being challenged by an outsider. In this case, the tenants are desirable parties because they have interests that can potentially be affected. But since they are not the main parties in the dispute, their presence is not needed for the proper determination of the suit. Now, in the case of Colonel Hassan Yakubu, retired, and the governor of Kogi State and others, the Supreme Court affirmed the decision of the Court of Appeal, saying that the fifth respondent was not a necessary party, since each of the reliefs sought by him could have been adequately determined without the fifth respondent being a party. And finally, the nominal party. A nominal party is a person who is made a party to an action by virtue of his office, and so although he may not have any personal interest in the suit, he would still be made a party by virtue of his office. For example, if there's a dispute involving the Federation, the Attorney General of the Federation will be the nominal party. If the state wants to institute a civil action, then the Attorney General of the state will be a nominal party. If it's a suit involving the National Assembly, then the nominal party will be the National Assembly. And if a state House of Assembly wants to institute or defend an action, then the Speaker of the House of Assembly will be the nominal party. So joining a nominal party to a suit is purely procedural and helps to avoid procedural defects. Thank you very much for watching, guys, and remember, stay lawful, stay informed.